Welcome to 80/20 Estate Planning, the show that explains smart ways to get the most from your estate and planning team, with your host, Al Gibbons. In this 13-week series, Mr. Gibbons and his guests will be discussing a multitude of critical and helpful topics, including his own 80/20 process. Feel free to call in with your questions, 621-WALE or 1-877-621-WALE. Now, 80/20 Estate Planning with Al Gibbons.
Welcome to 80/20 Estate Planning. This is your host, Al Gibbons, and this program is about doing 80% of your estate planning in 20% of the time normally required, from A to Z in 60 days. Today I have two wonderful guests with me, Mr. Tom Forrest. Tom Forrest is Senior Vice President and Manager of the Personal Trust Office in Delaware for U.S. Trust. Mr. Forrest is a past president of the National Association of Estate Planners and Counsels. He is immediate past treasurer of the Delaware Society of CPAs and immediate past chairman of the Tax Committee. He is the current vice president and program chair of the Delaware Estate Planning Council and has served as a board member of the Philadelphia Estate Planning Council. Tom, welcome to 80/20 Estate Planning.
Thank you. It's a pleasure to be here.
Nice to have you with us. Additionally, we have Norris Wright of Morris, James, Hitchens, and Williams. Norris is the senior member of the Estates and Trusts and the Tax and Pension Benefits practice groups. Mr. Wright's practice focuses on tax problems of individuals, including estate planning and probate, with a particular emphasis on tax planning for professionals, including physicians and others. He often represents clients in disputes before the Delaware and federal tax authorities. Norris, thank you for being with us today.
It's a pleasure to be here. Thank you.
We have two experts in the world of trusts, and in 80/20 estate planning, just as we try to get 80% completed in 20% of the time, today we're going to try to learn a large percentage of what it takes to do trusts in a short period of time. So we have a lot of ground to cover, and we're looking forward to it. Let's start right at the beginning. Last week, before we get to that, last week in our fourth part of the series, we talked about basic estate planning tools. And we also talked about, briefly, the selections of guardians and executors and trustees. And today we're going to talk more about trustees, Tom and Norris. But let's talk today about trusts and help our listeners understand how these scary and complicated things really work. Norris, if I were to ask you, if I came to your office and said, I need some estate planning done, and you agreed and we worked together, how would you explain these complicated things to me?
Well, the use of trusts is something that works into estate planning for about three reasons. One of them, we often use trusts for avoiding probate, which means the process by which a register of wills or probate court handles and administers assets held in the sole name of a person who dies. And sometimes those procedures can be cumbersome and sometimes expensive. Not in all cases, but in many cases they can be. So we sometimes tell our clients that the use of a revocable funded trust is something that they might wish to incorporate into their estate plan. And in order to fund the trust, they would transfer the title of some of their assets, such as stocks and bonds, brokerage accounts and things like that, into the name of that trust. And in the event of their death, there's a seamless transition to the takers of the trust, the beneficiaries, without having to go through the Register of Wills office. So that's one reason we might suggest a trust to our clients. Another reason is, in the event of the death of a client, there is some federal estate tax planning that needs to be done. Some of that includes having a trust for spouses and trust for children and using what's called the federal exemption, which is, as you all know, is now $675,000 and is scheduled to increase to $1 million over the next 6 years. But we also use trust for that so that we make sure that each spouse, no matter which one dies first, is able to capture their exemption. And then the last reason we often suggest trusts in the general format is to protect the trust in the event both spouses are deceased for the children, so that the children don't just receive the assets in one lump sum, we can have a trustee continue to manage those funds over a period of years, and the person who creates the trust would identify at what years the children would receive income or the right to withdraw principal, and would also, the trust would describe to the trustee what discretionary distributions the trustee might wish to consider for the benefit of children.
Okay.
So those are the three main reasons when people come to our office that we cover. There are other uses of trust, but that's the general approach.
So let's see, Norris. Then you mentioned that one might be for avoiding probate. That's a big reason, right?
Correct.
And the second would be sort of a tax reason that people might use trusts. And the third would be, let's say, tax avoidance or tax management. And the third might be to protect the children, and this would be sort of an investment and a control issue, value issue, all that kind of stuff.
That's absolutely right.
And then I think you said in the third one, when we were talking about taking care of the children, you also brought up this trustee issue, and I think we should talk about that today, not right now, but let's come back to this. That sounds like a very important position in this whole scheme of things when you're putting it together for your clients.
Yeah, it's a very key issue because you can, in many instances, you can write all the language you want into agreements, but if the people aren't there to carry it out and to enforce that language, it's a waste of time. So the trustee is an extremely important factor, and also successor trustees if the trusts are going to be long-term. Okay, good. Now, Tom, let's go back to this first point that Norris brought up, and he talked about avoiding probate. Both of you do work down in Delaware, and in addition to that, you have Pennsylvania and New Jersey and Maryland right around you. When we talk about avoiding probate, this first sort of general kind of trust that Norris was mentioning, is probate the same in every state?
No, actually, probate varies from state to state and is a state issue. For example, for those that are not familiar with what probate means, is probate governs where the distribution of your assets that are in your own name flow under your will, or if you have no will, through the intestacy laws of your own state. And in Delaware, for example, any assets in your own name that are subject to probate are subject to a 1.25% tax, or 1.25% filing fee with the Register of Wills. Pennsylvania is a little less. Each state is different. Norris, are you familiar with what Pennsylvania's rates are?
Well, they're nominal as far as what the probate court gets paid.
Okay. So if you had a state where you were going to be probating that had high charges, or there may even be some other considerations, that would certainly be a state then where you think about putting this kind of trust together. Is that so?
Yes, that's correct.
Okay.
But there's another use for a revocable funded trust, which means something you create for yourself during your lifetime.
Okay.
And that is, if you should become incapacitated and the assets are in the trust already, the trustee can manage those assets for your benefit and pay your bills and take care of things without needing to go to court. If you do not have a revocable funded trust with assets in it and you become incapacitated later, you may have to go to court, or someone may have to go to court on your behalf to be appointed as your guardian of the property in order to take care of things, and the court processes are somewhat expensive and always create delays. People use powers of attorney very often to help take care of that problem, but we find that use of a funded revocable trust is a much more effective tool.
So, Norris, then, trusts don't only come into play when you die for your beneficiaries, but very much can be very important during your own lifetime.
That's correct.
Okay. Now, let me ask a question. The second category of trust that you were talking about had to do with savings on estate taxes and so forth. Does this first one, this revocable funded trust, does this save estate taxes?
Not by itself, no. By the estate tax planning can be done by using trusts that are created in your will, as opposed to having to use a revocable funded trust during your lifetime.
So do you see confusion in this sometimes among your clients, Norris? do they sometimes think that these kinds of vehicles save them taxes?
Yes, they get it confused very often, and the use of a funded revocable trust does not preclude estate tax planning through the use of a will. It's the two are separate. You can do the estate tax planning without a funded revocable trust.
Tom, when you're talking with clients for the first time, is there some way that you describe a trust, a little story or scenario that makes it clearer for people and maybe not as scary?
Yes, we usually go through a scenario involving what a trust can accomplish. For example, I always ask, what do they want to have accomplished in their estate planning before you even get to taxes? You want to look to see what they really want to have happen after death. This is also what helps during lifetime to see what they want to have happen during their own lifetime. And how a trust fits in, for example, I'll give them the examples that they can have professional investment management and control of their hard-earned assets, inside of a trust document where they can hire investment management professionals if something were to happen to them. I always use the example, if they create a living trust or a revocable trust and they become incapacitated or ill or sick.
So what Norris was just talking about.
Exactly. The trustees, their assets are safeguarded, protected. They have professional investment management while they're incapacitated, and plus distribution of assets if they need distribution needs. The trustee is there to make distributions to heirs or for their bills or for health, maintenance support, anything that may come up. The trustee can step in and pay those. Versus in Norris's example, without that, who has the power of attorney? Who has the checkbooks, et cetera? Who can move the money around to find the bills to pay? This is all eliminated with the use of a trust.
Okay, so we've put this thing together, Norris, and have discussed the need, and you mentioned something pretty important, that it was funded. Now, it seems to me that I've seen things in a number of cases where there wasn't anything in the trust. Can we talk about that for a second?
Sure. It's perfectly okay in Delaware, at least, and in most other states, I imagine, that you would have what's called a dry trust. You would have the document signed and ready to go, and if it's inconvenient to put assets in there, or you have plenty of assets, but they aren't of the type that you can move into a revocable trust, such as an IRA or profit-sharing plan cannot be moved to your own revocable trust, you could still have it there ready to receive assets at any time. So some people prepare them knowing that they will fund them later, but at least they have their estate document in order and all ready to go, and they can amend it because the word revocable means they amend it during their lifetime. So they don't have to fund it, but if they do not fund it, then it's not effective for probate avoidance purposes.
Well, let's hold this thought. Let's take a break now and come back after the break, and let's talk a little bit more about funding and then see how the trustee can help us in this process. We'll be back right after the break.
80/20 Estate Planning will return after these short messages. Mortality. Who dwells on it? But when it comes to planning your estate, it's never too early to start. For smart ways to get the most from your estate and planning team, you need to hear Al Gibbons, creator of the heralded 80/20 Estate Plan. Implement 80% of the planning you need in 20% of the time it normally takes, from A to Z in 60 days. Contact AEG Financial Services today at 610-917-8940 or email them at algibbons@algibbons.com for more information about Al's expert services and related products. Al Gibbons of AEG Financial Services is a highly respected expert in the complicated and often confusing world of estate planning. Put his years of experience in dealing with real situations to work for you. Contact AEG Financial Services today. Call 610-917-8940. That's 610-917-8940 or email algibbons@algibbons.com.
Did you know that some ethnic groups have an AIDS infection rate 8 to 14 times that of white Americans? Did you know that there are powerful foreign interest groups behind the push for more and more restrictive gun control laws, and that their goal is to disarm American citizens so that we can never rebel against tyranny? American citizens need to know the truth. That's why you need the National Vanguard Books Catalog. For only $1, they will send you their big book catalog for patriots, listing over 400 books, tapes, and videos that the censors of political correctness don't want you to see. Send $1 today to National Vanguard Books, Department R, Post Office Box 90, Hillsborough, West Virginia, 24946. That's National Vanguard Books, Department R, Post Office Box 90, Hillsborough, West Virginia, 24946.
Talk to our expert host. In the Providence area, call 621-WALE. Outside the Providence area, call toll-free, 1-877-621-WALE.
And now back to 80/20 estate planning. Here's your host, estate planning expert, Al Gibbons.
Welcome back, listeners, and welcome back to you, Tom, from U.S. Trust in Delaware, and also to Norris Wright from Morris James in Wilmington, Delaware. We're talking about trust today, and we're talking, spent our first segment on revocable living trusts, and we're getting into the areas of trustee and so forth. But before we do, Norris, there were three categories. One, the first, the revocable living trust, avoiding probate and some of the other advantages. Secondly, we talked about trust for estate tax planning. And thirdly, we talked about for protecting children. Tom, you mentioned that there are a lot of reasons, and we spent a lot of time on this in our first show, why people who think that they're coming in to save taxes as their primary reason to do estate planning end up realizing that taxes are really fourth or fifth or sixth on the list. There are some reasons that you get to way before the tax issues. Let's talk about trusts for children, why we have them, and what they can do. Tom, will you tell us a little bit about that?
Well, there's several types of trust for children. Al, did you want to highlight the trust for children during lifetime or ones created in case of death under a will?
Well, I mean, let's do both. We have both, but let's also talk about sort of the investment issues and the control issues, the incentive issues, some of those things. Yeah,
there's been a shift in recent years on trust for children generally, and I'll talk to Norris a little bit later to see if he agrees with this shift in the thinking of distributing assets from the trust to children today. A lot of the trustors or grantors we meet with or individuals are concerned that, especially the ones on the wealthier side, that they don't want their children to have outright lump sum amounts of money. They want to make sure that they're out there earning a living and they're turn out to be, hard-earned good children. So we're seeing some trusts that have restrictions in the trust where they might have a 5x5 power, for example, where they get the rights to income and then they're allowed to withdraw the greater of $5,000 or 5% of the trust assets on an annual basis, just to provide some extra principal to that child. It's also common for some of the for spousal trust also. But also on the children's side, we see a lot of them set up for educational purposes. I've had several individuals come to me and say they don't want to distribute to their children unless they maintain a C average. We'll get into this a little bit later about, the hardships a trustee has to go through to administer such a trust. But that is a common mindset today. They want to make sure individuals out there today that the children are hard workers and earning their rights to the trust income. Norris, have you seen this recently in your practice?
Yes, we call them incentive trusts, where the people creating the trust feel that perhaps handing over too much wealth to a child, even in their mid-20s or early 30s, is too early, and they might cause the receipt of that wealth would cause the child to become less productive, and therefore they don't want to shut off the total access to money, so they want to provide incentives there, and that's becoming more popular. But as you pointed out, Tom, especially from your position as a vice president of a major trust company, that's a very difficult thing for a trustee to manage. and there's going to be people knocking on your door quite often asking for money, and then you have to go make these determinations.
So, Norris and Tom, we're talking about a trust for the beneficiaries where, as you said, Norris, you call them incentive trusts, and they're sort of referred to that way in the industry. Who does manage these? Who makes the decisions? How do you put these things together, and how can they be enforced? What kind of trustees do you use? Let's talk about some of those issues, Tom.
Well, depending on the degree of
give us some examples, maybe some that you've run into down at U.S. Trust or in your history in the trust business.
Well, we've seen all types. People want to control everything they can. Some individuals that are children. In fact, I've had one situation where the individual or the trustor wanted us to contact each issue and child and remainderman each year.
That's all the beneficiaries. Right?
All beneficiaries of the trust, even discretionary beneficiaries, as well. I'm sure we'll get into a little bit later. That to make sure if they're in school, that they maintain a C average, to make sure they have a job, and some of these things we just told them we can't do that. It's not feasible for a corporate trustee to do that in all cases. So what we highly recommend a lot of times, and Norris advises this, is the use of advisors or third parties out there that can be written into the document that can provide this information to a trustee. The use of advisors for distribution advisors or for incentive purposes for reporting the information back in to a corporate trustee. Now,
so you're saying, Tom, that this would be a daunting task for a trust company or a trustee to try to go find out whether people have complied or reached milestones or done different things according to the document. It would just take too much time.
Absolutely.
Is that what you're saying?
Absolutely.
Okay.
It could be a very expensive way to manage a trust because it involves a lot of time as follow-up to make sure we're meeting the demands of the trustor.
Norris, are you seeing, it would seem to me that good grades, a job, college education, those would be sort of normal things. Do you see some abnormal things that people are coming up with today in incentive trust planning? Anything?
Yeah, I hear them, and I generally try to discourage them to a degree for the reasons that Tom has put out there. But there's some religious-based ones sometimes where people marry outside of a religion, they're cut off.
Excuse me, Norris. Isn't that what happened? Wasn't there a front-page Wall Street Journal article that Senator Lieberman ran into as a trustee where there was a marriage outside, and it probably would not have been the intent today? So some of the intent changes in these things.
Yeah, well, and that's one thing I try to explain to clients, that they're telling me based on today's system of education or today's system of customs or marriages or whatever, the problem is 50 or 100 years from now, if these trusts are to continue that long for grandchildren and great-grandchildren, all these systems may not be there. So the words they use in the trust may not even be applicable, or the customs may have changed considerably. So we also sometimes, either the beneficiaries go to court and request the court to reform the trust, or we put in something that's very exotic called a trust protector, which is somebody who assists the trustee in amending the trust for certain purposes. But that's a very esoteric approach, but that in trusts that are going to last a long time, we sometimes try to provide some what we call wiggle room or flexibility in the future to adapt to things that change in the future. But you can't escape what the feelings of the person creating the trust are. They very often have very definite feelings, and they want it in writing, and they want it adhered to by the trustee. So we try to build in some flexibility for the future, but people have some very strong feelings about certain things.
This seems like it would be so easy if I were putting a trust together. There are some values that would be very significant to me, and I would think that the rest of the world feels the same way, and let's just put them in the trust. And I guess, even though I didn't know it, I would be looking to you for some kind of leadership, to you and Norris telling me why these things are difficult to work and why they don't work. And then it becomes very important to deal with specialists in this area, people who have a lot of experience, so I guess who have seen it from all sides. And both of you have been there. And I think your advice is probably most appreciated in that area, at least to point out to me what those pitfalls are and what seems like such normal things. Well, we'll make sure that the child graduates from college. Well, it may be someone who doesn't have the ability or the desire or wants to become an artist and not graduate from a 4-year institution. So I guess there are all kinds of things that can happen. Let's talk some more about that, but let's take a break first, and we'll be back in a few minutes.